Welcome to Ask the Attorney, brought to you by the Law Office of Chris Doskotch.
Hello and welcome. I'm Stacy Campbell, and we are ready to take your questions, so you can begin calling right now. The number is 698-3742. Our attorney this evening is Chris Doskotch, a personal injury lawyer with a practice on North Knoxville right here in Peoria. Hello and welcome, Chris.
Thank you and good evening.
Yes, so we are talking about a topic today that we haven't really touched on very much all the times that you've been here, but I think it's one that people can really relate to. It's repetitive trauma injuries.
Yes.
And so I just want to start with you kind of explaining what that is.
Okay. Well, in workers' compensation, you can have an injury from a specific accident, lifted an item, your back hurts, twist your knee, stepping in a hole. Repetitive trauma, I prefer the word cumulative trauma,
Okay.
and it means injury that occurs over time from doing an activity on a repeated basis that causes the breakdown of whatever body part you injured. So that would be, in general, what a repetitive or cumulative trauma
Okay.
case is.
Okay, and I know one point that you want to get across is if you think you have a repetitive trauma case, the first thing you should do before reporting it to your employer or reporting it to a doctor is to call an attorney.
And we'll talk about that, I think, a little bit later, or reinforce it. When you have a specific injury, you know, you're going to take care of your health, and you're not planning that, so
Right.
you don't have time. But cumulative or repetitive trauma cases, they occur over time. So if you think you have a condition that might be repetitive, why not call a lawyer first to find out what it is, what you need to do to report it, what's
Right.
important about reporting it. Like one of the graphics up there talks about what's the definition of repetitive. There is no exact definition.
Okay.
Every case is its own case. It could be 10 times a day. It could be 100 times an hour, because it's based on really, you know, how many times do you do it, how much force, what's your body mechanics, how do you move your body, and how long you perform that activity, duration, frequency, and force.
Okay.
And so those are the things we would talk about before that you need to tell your doctor about.
And so what are some of the, so carpal tunnel is one that comes to
That's the
mind. Classic,
Number
repetitive.
one, if you ask anyone, that's the number one. Carpal tunnel, which is a compression of the nerve at the wrist, and you get numbness in the first 3 fingers. Another is cubital tunnel.
And that's the elbow.
That's the elbow, and that's the last 2 fingers. You can get it from lateral epicondyle. People, mechanics who do a lot of wrenching, will get like tennis or golfer's elbow. Shoulder impingement, you hang drywall, you do a lot of hammering or work overhead or lifting away from the body. In work comp, though, for repetitive injuries, for example, walking, like you walk all day and you
Right.
develop plantar fasciitis, is it related to that? Probably. Not going to probably win that case.
Really?
Back. You know, I do a lot of lifting at work. That the work comp, the people that decide the cases have a bias towards accepting cases for carpal, cubital, the elbow, the shoulder. It's a lot more difficult for the back, the neck,
Right.
the knee. Like some squatting or knee cases could be a concrete finisher that's on their knees all the time, or a baseball catcher who's kneeling or squatting all the time in their knee. But those are more difficult. So the primary focus for us on repetitive stress involves the upper extremities, wrists, elbows, shoulders.
Okay. And remember, if you've got a question, you can give us a call. The number is 698-3742. And we do have a question here from James. I drive a truck for a living. A few months ago, my hands started to tingle. The doctor said I have cubital tunnel. Can that be related to driving a truck?
Right, and we were promoting the topic here, and that was one of the questions that had come in ahead of time. And driving, I mean, every case depends on what a doctor says first. Do they think there's a relationship between the job activity and that? So driving, to get a cubital tunnel, there has to be a lot of flexion of the elbow, forceful gripping, maybe vibration. That you're not going to get that driving a vehicle. But where I see it a lot of times for people who drive, because I notice this myself, I don't do it anymore, is resting your elbow on a hard surface will cause pressure over your elbow or the nerve, and it will cause cubital tunnel, so prolonged.
What kind of hard surface?
Well, if you're driving, your armrest, or you know, in your console of your vehicle you have, or your truck, you might have an armrest. People who type and rest their wrists or their elbows, that pressure actually over the nerve affects the blood supply.
Yeah.
And it's the blood supply that causes the nerve to have symptoms or pathology that causes the numbness. So it could be, but it would depend on the ergonomics in your case.
Okay. Another question from Kyle that was sent in. I tore my ACL at work, had surgery, and now I have returned to my regular job. Can you give me an idea as to what my case is worth?
Okay. I can give a general idea. First, every case is based, the value is based on how much you make.
Okay.
So that's a first issue. I don't know. The more you make, whether this is right or wrong, it's the way it is, the higher your settlement is for the same injury.
Okay.
Then they look at, is there an impairment rating? Did you return to your job? How old are you? What type of job do you have? Have you lost earnings on a permanent basis because of your injury? And how did you turn out?
Okay.
So you look at those factors, and if you did well, someone might say, well, you're going to get a percentage of disability, like 25 to 30%. Old way, now it's less. But for a specific case, I'd have to see the operative report, how you're doing, and look at those factors to give you a more specific answer.
Okay. And people can call and ask those questions for free, right? If they think they have a case, they can call you and ask you questions.
Correct. And for me to give someone that opinion without that information specifically would be extremely difficult.
Yeah, but they can come in and meet with you, and you can decide whether or not.
They can talk on the phone, and we can do that. There's no charge for that, and we can discuss that.
This is from Warren. Can you have a work-related case for a heart attack due to stress? That's a great question.
All right. Yes, if we got a second, these could be complicated.
Okay. So far we do. They haven't told me that we don't.
All right, the stress. And it depends if they're talking, so I don't know. And if I was in the phone con, my next question, what do you mean by stress? Are you talking physical stress or, emotional stress?
Okay.
If it's emotional stress, those are extremely difficult unless the circumstances of the stress are so beyond what you would expect for the job.
Okay.
So if you're a head football coach and you have a heart attack, that's a very stressful job. You're sleeping late. I mean, you're not going to have it. But if you have a job with very low stress and you get a new boss and they're making you work 20 hours and it's just beyond the norm, possibly, but tough.
But it would be hard, yeah.
But on a physical stress situation, most of the cases people have pre-existing conditions. They might have narrowing of the arteries, they may smoke, who knows.
Okay.
But if you're lifting and doing physical exertion contributes to the heart attack, in that situation, then it would be worth investigating, and you'd have to find out what your physician would say.
Okay, great. Well, it's already time to take a break. I know you have lots of questions, so we will be right back with Chris Doskach. And more of your questions, try to find out what it takes to win one of these cases in repetitive trauma. Stick around. And we are back with Chris Doskach, a personal injury lawyer here in Peoria, taking your questions at 698-3742. So you can call now if you've got a question for Chris. So we've been talking about repetitive trauma cases, things like carpal tunnel, cubital tunnel, which is the elbow. We also mentioned the importance of contacting an attorney if you think you have a case, and we'll talk a little bit more about that. But what I want to talk about now is how winnable are these cases? Because you say they can be difficult.
Well, they were difficult when I started 20-some years ago. There's another lawyer in town actually who helped bring this about, and since John started doing that in the late 80s, we've really been fighting that battle, and it kind of got settled, and then we've had some changes lately, and it's more difficult. So they are difficult. The more physical your job is, the easier it is to prove.
Okay.
The less physical your job is, like if you work in an office right now, it's very difficult to prove. Or if your job's lighter, a lot of jobs have been mechanized, so they're not as physical as they used to be. So you got to know more of the details and
some of the elements to winning a case.
Plus the elements too are just, you have to report the case within 45 days to your employer.
Okay.
But you can talk to someone beforehand, so like we talked about, on how to report your repetitive trauma and your symptoms. A lot of people don't even know what they have. My hands are numb. That could be a number of things. So then you have to have an accident date, and that's usually the date you sought treatment and received a diagnosis of a condition that would be considered work-related. So the first day you go in and say, my hands are numb. The doctor does one of those needle tests that nobody likes, an EMG. Come back and it says you got carpal tunnel, then your accident date's going to be the date you're diagnosed, because you don't expect someone to self-diagnose themselves.
Yeah.
So you got to report within 45 days of that accident date. And then most importantly is, and this is very important, most people who develop, rotator cuff, carpal tunnel, you may have pre-existing conditions or conditions that make you more susceptible. But if your work is a causative factor or an aggravating factor, it doesn't have to be the sole or only.
Doesn't have to be the only factor. Just
Right, if it
factor.
was, then there would be hardly any cases.
Okay.
Because,
Yeah.
as we get older in life, that's
Things
how
happen.
things work.
Yeah.
And then that opinion has to come from the physician. You have
okay.
to have expert testimony to prove
Okay.
a repetitive stress case in almost every situation on that issue of causation.
Okay, so we have had a question from Lorraine. Is there an amount of weight that I have to use or lift in order to make it carpal tunnel? I was sent to a doctor who said it was not work-related because there wasn't enough force.
Okay.
You were kind of getting into that a little bit.
Right, on carpal tunnel, there's not a lot of force. I mean, it's not like you're using a jackhammer.
Right.
Or, you're working with an impact wrench or something like that. So you're typing. There is a lot of physicians that don't think that that is forceful enough to contribute to carpal tunnel, and then there's other physicians that say if your wrists are bent, there's stress over the median nerve. In my experience, it's my opinion it is, but I'm
Yeah.
not a doctor.
Right,
And so there is no de minimis force,
yeah.
but it comes down to what your doctor or your expert thinks. And then really what it comes down to is what does the judge think?
Yeah.
It doesn't matter what we think. So if the judge says there's not enough force, there's not.
Well, I know some days at work, if I happen to be typing more than normal, I can feel it. And I'm not, it's not forceful. It's
Right.
not forceful, so.
Right, no one's typing
Yeah.
like crazily,
Yeah.
And so the question is, does it just manifest or come up when you're doing the activity because you have the condition, or is your work activity bringing or exacerbating the
Right.
symptoms?
Yeah.
That's really the argument. I think it is. These cases were really settled, and now we've kind of gone back into this era, and I think it really comes down to the strength of my client's testimony and their medical opinions.
Okay. Here's a question that was called in from Alan. It says he had x-rays 8 years ago and they were okay. Recent x-rays show bone on bone in the knees. He works in manufacturing, walking on concrete. Would that be a viable case or a work comp
Okay,
claim?
and I was touching on that beforehand.
Yeah.
And there's a couple issues. One, the x-rays before show that you were better, and it wasn't that symptomatic. Walking on concrete, you'd have to keep track of how much you walk, the type of shoe, and have a doctor to say that that activity contributed to your osteoarthritis in your knees.
Okay.
Unfortunately, those are tougher cases, and,
Yeah.
and this is the reason why. I'll be the other side. Because everybody who walked, who then developed an
Yeah.
arthritic knee, and they're standing on their job, they're going to say, well, that's work-related, and
Yeah.
it becomes more positional risk than the job really being involved in it. So it may talk about what type of walking. Were you walking on hills? Like this person said, is it concrete? It's not an easy case, especially under the environment right now, but first check with your doctor. If your doctor won't support you, you're not going to get
Yeah.
anywhere. But remember those deadline dates too, because if you want to do it and you've been to the doctor and they diagnosed it, you got to report it
Yeah.
and file within so much time.
And you were telling me before the show too that a lot of times with like knees and backs, you have to have a specific injury related or a specific accident related to the injury for it to be.
Yeah, many people will call and they'll say, my back hurts, what happened? Well, I was doing a lot of lifting. And then you get into it, what
Yeah.
were you lifting? Well, I was lifting these, air compressors.
Yeah.
Okay, how did you report, was this reported? If you just said I did a lot of lifting, nothing specific,
Yeah.
it's going to be a hard case to win because they don't because again, same thing, you have a hard job, your back hurts, everyone would have a case. So it's a way to limit exposure and for them to pay, to
Yeah.
limit the number of cases. So when it involves the back or the neck or the knee or the ankle, the
Almost
more
need a specific accident.
yeah, if it's coming
Okay.
on and you lift and you notice your condition gets worse, talk about, I do a lot of lifting at work, but when I was doing X, I noticed this symptom.
Okay.
Because they're really the same thing sometimes.
Yeah.
It's just people aren't thinking when they're going in that I have to be that
Yeah.
specific.
Okay. All right, great. Well, we have to take another break, but
Okay.
we're going to come back because we've got lots of you asking questions. More questions to Chris Doscotch on repetitive trauma coming up next. We are back with Chris Doscotch, a personal injury lawyer right here in Peoria. You take many types of cases, including repetitive trauma cases, which is what we are talking about tonight.
Right.
If you have carpal tunnel, you certainly know what we are talking about, and these cases are not necessarily easy to win, which we were kind of talking about before the break. So let's talk about what needs to happen to win these cases and why they are so hard to win.
We've already touched on it.
Yeah.
If you have a repetitive stress case, I mean, the insurance companies, they know what they're doing to defend them. Call and ask questions, because how you report it
Yeah, let's talk a little bit about that, how you report it. To who?
to not only your employer, but your physician.
Okay.
And so talking about the activity, like if you had carpal tunnel and you think you might have it, I might give a suggestion, say for the next 2 days at work, keep track of how many times you do X. How many times do you do Y?
Okay.
How much weight are you lifting? How many hours are you typing?
Okay.
What is your ergonomics? Know all that information. So you can give it to your employer and you can give it to the doctor, because for the doctor to give an opinion on whether it's work related, the doctor needs to know
What you do.
What you do. And if they don't, then I'm on the other side. I'm like, do you really know what they do? Well, I don't really know how much. And then how valid is that opinion? So that's super
Sounds
important.
like you kind of have to have a very good job description of what you do.
Correct, because the ones
give
the
the doctor.
company has is not going to have all that information.
Okay.
And what's better than you keeping track of what you're actually doing? And another technique is if people are guesstimating what they do, then they try and make it look like, oh, you said you lifted 20 pounds, but it was really 13 pounds.
Okay.
And that might be a distinction without a difference.
Yeah.
But it makes you defensive, and it doesn't, so you want to be that's the best way to be accurate too, and to take that away, from that defense of the case.
Okay, and we do have some pointers up on the screen now for kind of helping to win these cases.
And the last two we talked about all of them. The third one, multiple employers, a lot of construction people, or even if you work at Caterpillar and you used to be using air guns all the time and now it's more mechanized, know your job.
Okay.
It doesn't start in that current job. They can't wipe out your past work history.
Yeah.
So you take everything into account. In the politics of it, it's just the way it is now, the way judges are appointed, and there's been a lot of pressure to reduce repetitive stress cases because of Menard, and whether that's right or wrong, that's a different day, but that's the reality. So whatever you did to win your case 10 years ago, you need to do twice as much to try and win.
Okay.
Especially if you're not, jackhammering or out doing very forceful, labor-intensive work.
Okay. David has a question. My work paid for my carpal tunnel. The company made me an offer, and it's lower than what my coworkers had gotten previously for their carpal tunnel claims. How does the attorney fee work if I already have an offer?
Okay. Well, two things out of that. What I do, and everybody's up is different. I charge 20% if you come into me before, but if you have an offer, I charge generally 30% above the offer. There's no fee on the offer amount.
Okay.
Never more than 20% of what you obtain.
Okay.
It's not going to hurt. A lot of times I'll just get the records in, I'll look at them and see if I could I'm not going to try and get you $600. It's not worth it. And then we can make that decision. And the other thing you got to keep in mind is, number one, you don't always know exactly what your coworkers get, because sometimes it sounds more than it was. And then secondly, the other thing is things have changed and the awards are down.
Okay.
So what you may have got or someone else may have got 3-4 years ago may not be the same now. So that's where you got to have a good attorney and be able to rely on what the current values are.
Okay. Question from Sarah. I had a work injury to my elbow. Work comp won't approve any treatment, and the doctor won't see me until it is approved. I have group health insurance, but the doctor won't take it. Is there anything I can do?
Scream?
That sounds like a good thing.
That's a good answer. But no, that's a very common problem. They did change it in a favorable way. The doctor's office can bill the group insurance, and then there's provisions for them to be reimbursed or credit given. Because the main thing, if you pay for health insurance and you're paying for work comp in your employment package, you should be able to be seen by someone.
Yeah.
And you shouldn't get stuck. But the problem is the doctor's office, it's elective unless it's an emergency situation. they don't have to see you. So
Okay.
if that doctor's office won't do it and you're kind of stuck until you get a diagnosis, call around and see if another office will
Okay.
do it. Or, you know, I tell people pay cash, use your group, because you want to get seen and get a diagnosis so we know what to do.
Right. Okay. This question was called in from Debbie. I had hip replacement surgery. There were complications. Anything that can be done?
All right?
We don't
it
have a lot of
depends on what-
information. We don't have a
doesn't-
lot of information. in that
Depends
one.
on what the complications
Yeah.
are. If it's a medical, I mean, that's not something I do, but
Right.
what the person may be getting into is there's been a lot of recall information and
Oh,
stuff
okay.
like that.
Uh-huh.
Any implant you get, they have a lot number. You should be able to get that. You can look up if there's been any type of
Okay.
product issue. In terms of complications, they're generally complications with the procedure. Every
Yeah.
case is individual. You would need to call a lawyer for a
Okay.
medical. That's not something I do.
Right.
If it's in a work injury and it's a complication of your surgery,
Mm-hmm.
then any complication is covered just like the initial
Okay.
condition.
Okay. Brent asks, he had back surgery and surgery recommended. I don't want it because I can't afford to be off of work. I guess back surgery was recommended.
Right.
I'm afraid to close my case in the event that my back gets worse. What would you recommend?
Well, I mean, surgery is pretty major,
Yeah.
so that's pretty reasonable, and I'd avoid surgery if you can. If you hire a lawyer, we have 3 years before your case becomes too old
Oh,
that you
okay.
have to do something.
Yeah.
So if it were me and you don't have a particular use for your settlement money and you're concerned about that, if it were me, you got 3 years to file your claim. If you file it, then you have 3 years before the judge pressures you.
Oh, okay.
So I'd leave my case open as long as I can
Uh-huh.
to make sure things don't get worse and you have surgery, just to leave your options open.
Okay. We have so many questions. We're never going to get to them all, and we apologize for that. But you can always call Chris and ask him if you
Yes.
have a case. Alicia, I saw a work comp doctor for a second opinion. I liked this doctor and would like to switch to him even though he's in Chicago. Can I do that?
You can, and that was one of the write-in ones.
Uh-huh.
Okay.
Yeah.
And that's a good question because I've had some clients do that. You can if that doctor will see you. Obviously, if you're going to the doctor chosen by the other side, you got to take that
Yeah.
into account. But many times the doctor will take you on as a patient. There may be a little bit of a conflict there, but a lot of doctors will waive that. And
Okay.
you just got to make sure you're comfortable with whatever physician you choose.
Yeah. And these are always just such complicated waters to navigate. And so anytime you have any questions, I think it's always important to call somebody who's an expert in these types of things, which is you. We don't have a lot of time left, so I want to get to how people can contact you if they're interested in giving you a call.
Sure. They can give us a call, 309-681-9770. Internet, you can email questions. We'll respond promptly, chris@doscotchlaw.com. You can go to our website, www.doscotchlaw.com. Any of those ways will work.
And you have an office on North Knoxville and on North Adams? In
Yeah,
Lewiston. Oh, you're in Lewiston as well.
Right, and we
I always
have an
forget that.
office in Lewiston. My wife's from over in that area, and so we go to Fulton County and have a lot of clients from that area as well.
Okay.
But again, call, ask questions. It doesn't cost. And again, if you have a problem, even if you don't want to hire someone right now, if you come back later, I'd rather have talked to you
Yeah.
about it beforehand than coming in with the problem.
Yeah, I think there's a misconception that people think if you call that it's going to cost. No, you can always call and ask a question
Just ask a
for free. Any final words that you'd like to say tonight?
Nope, just getting ready for the kids to go back to school.
I know, it's that
Son's
time of
going
year,
to
isn't it?
college. My wife's teaching, so hello to my